So if we think about economic and social rights, they've often been the so-called poor cousin of civil and political rights, particularly in the constitutional and the theoretical spheres. Opposition to their constitutionalisation has been trenchant, manifold, and persistent. Critiques have included philosophical doubts over their moral status as fundamental rights, ideological resistance to the potential interference with free markets, legal uncertainty on their justiciability, and democratic and institutional worries about potential interference of courts with public policy. So the result is we've had this idea of generation of rights, economic and social rights being the so-called second generation that emerged after the Second World War, or if we use T.H. Marshall's historical taxonomy, they emerged at least in public policy and activism in the late 19th century after the rise of first civil and then political rights. The tide, however, has arguably shifted in the sense that economic and social rights have gained greater acceptance in philosophical theories of rights, particularly the last 20 to 30 years. Historians have revealed their long ideational heritage, for example, going back 1,000 years in Catholic social thought. Also, social rights also found in Locke, if you actually read Locke. Health rights are there, minimum subsistence rights there in Locke. But the opponents of economic and social rights have used Locke for very different reasons. The shadow of political economy is also partly lifted, particularly at the end of the Cold War, where we no longer associate economic and social rights with a particular economic regime. And now we're seeing, and particularly the focus of today, an increase of economic and social rights in the Constitution, and in 2008, the new complaint mechanism at the international level. And in many countries, we've seen the judiciary come on board, preempting this trend with implication of rights, recognising the rights as justiciable, and then starting to apply them. So the topic is constitution of economic and social rights, and this is based on a forthcoming chapter. And it's a very broad topic. So the question is, what do we mean by constitutionalisation? And a common definition you can find, for example, of what we mean by this is in a new chapter by Ron Herschel, one of the sort of godfathers of comparative constitutional law. And it's often we think about three things: Bill of Rights, which would include then economic and social rights, some form of active judicial review, it's as a second vector, and then a third vector is the engagement of constitutional courts and judges. And these three things will be my focus. So recognition of social rights, economic social rights, judicial enforceability, and then their judicialization. However, it's worth thinking about two other vectors. The one is quasi-constitutionalization, where you see the integration of economic and social rights in a somewhat constitutional form in legislation. Yesterday, we talked about the Queensland Human Rights Act with rights, health rights, services, education, arguably also family and children's rights. We also see it in parliamentary processes where, increasingly standing committees in different parliaments around the world have a clear human rights mandate. And Mark Kushner, another godfather of constitutional law, has really argued about, we need to look more at the way in which, for example, parliaments interpret human rights and see that as a form of quasi jurisprudence. And then we also have legislation, not only including charters and quasi-judicial review, like the British Human Rights Act. We have national human rights institutions increasingly also established under legislation with a kind of quasi-constitutional role. So I'm going to speak briefly about the end. And then what I won't speak about, but it's really interesting, is the rise of fourth branches of government. South Africa is a good example where you actually have a national human rights institution, and there's others recognised in the Constitution, essentially a fourth branch of government. The classic one is electoral commissions, but and particularly Latin America, there's all sorts of experimentation. And so it's a question in which, when these branches of government actually have mandates or take up economic and social rights, is that also a form of constitutionalisation? I'm going to keep myself to principally the first three to four, and ask two questions. but actually it gives us a very broad scope. First is descriptive, how, when and where with these vectors over the last 200 years, and then why. Why do we see that? And that is where I sort of also link into the Australian New Zealand context, where we've had less constitutionalisation of economic and social rights. Can we learn something from particularly social science theories about why we get these vectors and what that means? Does that resonate with these countries, and what are the prospects for further constitutionalisation in this part of the world? So let's start with the recognition question. 28 September 1776 is my date for when we fit the first constitutionalisation of social rights. Article 44, Constitution of Pennsylvania, a school or schools shall be established in each county by the legislature for the convenient instruction of youth, with such salaries to the masters paid by the public as may enable them to instruct youth at low prices, and all useful learning shall be duly encouraged and promoted in one or more universities. This emerged out of the common schools movement in the US, which is still going, because schooling was initially private, and when it emerged publicly, it was funded by local taxes, which meant if you're in a rich municipality, a great school, poor municipality, bad one. It's little known, even amongst American constitutional law scholars, that in every US state constitution, there is a recognition of the right to education. Initially, when they came, and Pennsylvania was the first. North Carolina adopted almost exactly the same provision a few months later. It comes in this form of a duty, and it's sort of a little bit, vague to some extent. Many of these constitutions were changed later to sort of the right to a thorough and efficient education. But courts have recognised provisions like this as essentially rights to education. So that's my stake in the ground as to the first recognition of social right. Others would say, particularly if you're going to have the requirement of a national constitution rather than a state level, that it's the French Constitution in 1793. In the actual initial constitution in 91, there were no economic and social rights, but 30 of the proposals that were sent to the Assembly included them from both the political left and the political right. And then that returned again in the 1793 constitution. It was rather short-lived because France was attacked and they were in a war, and the government declared emergency powers and therefore suspended the 1793 constitution. But at least that's the first recognition of economic and social rights. National constitution, you've got rights to work, association, public education, and public assistance coming then in 1793. If you want to go really historical and talk about proto-social rights, we're back to the Charter of the Forest, which came 2 years after the Magna Carta, which basically provides minimum subsistence rights and basic working rights. But so we get end of the 18th century, some recognition. With the rise of particularly labour movements of all varieties in the 19th century, many demands for economic and social rights, almost successes in 1848, but very few. It's mostly in legislation when things come. So the next breakthrough, and this is probably what I would call the beginning of phase of the first wave in the 20th century. It's the Constitution of Mexico in 1917, with a particularly recognition of economic rights, labour rights, right to fair wages, equal pay, social security rights, and some broader social rights. And it provides a template for many others that actually follow. I've done a new coding of constitutional recognition since 45, where we see the second wave, where, say, something like Italy might be a good template. Again, a bias towards economic rights, but also increasing social rights. And what I've done in this graph, if we just look at first social rights, is compared, so torture-free expression properties, 3 civil and political rights in the blue, darker blue there, the red and the green, with 4 social rights: healthcare, housing, living standard, and education. Education one is right at the top, along there with free expression. So on one hand, good, but that coding in the CCCP project is just where education is mentioned in the Constitution. So it's not necessarily right, whereas all the others are they're a clear right. I think healthcare is quite fascinating in the way it comes through in the third wave, which is really from the 1980s. I mean, South African Constitution is often put up as the sort of the archetype for that wave in 96, but it begins much earlier, particularly in Latin America, in the post-authoritarian space. But some social rights, housing, living standard, quite low, only a third of states. So around 2/3 of states, let's look at economic rights. Again, I compare some civil and political rights. And then you've got trade union rights, which are quite high. They're up there with torture. Then remuneration and social security. And if we also look at something like right to healthy environment, that's all in 2/3 of constitutions, as is trade union rights. In the middle, we get social security, remuneration, healthcare, half the constitutions, and then 1/3 housing. So great variance, but clearly an increase. So why? In my view, there's three types of theory. And the first two are common in the literature, particularly from Ross Dixon and Tom Ginsberg. So first is a bottom-up demand. Political actors, parties demanding this, but as we talked about yesterday, does it come from the left or the right? It sometimes comes from trade unions, but other times it comes from the centrist left, the Christian Democrats, and so forth. Social movements, I think, have been really key here. Perhaps women's movement, Indigenous movements at different points in time, trade union movements. But again, trade union movements at times have opposed economic and social rights recognition. Social democratic parties have also opposed as much as they've supported economic and social rights over the last 100 years. So, for example, getting through a Bill of Rights in Sweden in 1974 was basically pushed through by the conservative right and the communists against the wishes of the social democrats, who didn't want interference of rights, judicial review and all that came with it. So it's a much more complex history, and so I think perhaps Sam Moyne goes too far, and he's pushing it. So, it's very much a Christian thing, this, for example, social rights and human rights, but it really varies. And also you can have different types of constitutional moments. Sometimes you're trying to transform, sometimes you're trying to preserve something, and that has implications. Top-down strategies. The classic one, particularly for civil and political rights, is political insurance. So you basically try to lock in gains for a dominant group, and the types of rights to property or the free press that they've had. Less relevant for economic and social rights, except perhaps the end of the Eastern European communist governments, where there was an attempt to lock in economic and social rights as they were going over to a neoliberal market agenda and system. Countries like Hungary are sort of clear examples of that. More relevant is where you might see elites doing some sorts of trade-offs. Evan Roosevelt and I have sort of found potential bargaining trade-offs where you say, we'll give you one economic and social right, but we're not going to give you the other. And I'll give you an example of that in a moment. Ross Dixon has written about bribing, where an anti-democrat, an autocrat, for example, a military leader in 2006 in Fiji says, I'm going to retain anti-democratic powers, but I'll give you social rights. And you get those. So it's essentially, some sort of right. Another thing is reframing. So Gargarella talks about the 1917 Mexican Constitution. It looks fantastic for economic and social rights. But if you go back to the Mexican Revolution 6 or 7 years earlier, the demands from the trade union movement, the agrarian movement, the indigenous movements were much more radical. And so you could argue there was a sort of reframing of their radical demands into these moderate, acceptable demands. And many also say that the reason we got the ILO in 1919 wasn't really to champion labour rights, it was to pacify labour movements, particularly in the West, in Latin America. We are concerned about you, and please don't turn the communism. So here's an example of bargaining. If you look at Asia in terms of the types of rights, social rights and economic rights which are constitutionalized, look at right to strike and how low it is compared to the rest of the world in white. So East Asia and Southeast Asia are quite low, non-Asian much higher. But when you get up to something like social security, it's much higher, even rest and leisure, a fair wage and so forth. And basically what we argue is this reflects a Bismarckian model of the mercantilist model in the East Asian states, quasi-autocratic, want to be open to markets but have control of the running of those markets and protecting their own corporate actors, which the right to strike fundamentally threatens. And so we're not going to do that, but we'll give you these other rights. And then a final bunch of theories is more ideational, discursive. And so from institutional isomorphism, we get the idea of mimetic copying, that to be a modern state, well, you just have to have these rights in your constitution. And so it's just, you copy and paste to legitimate yourself as modern, or you just, you know. But then you can go to something like historical institutionalism and see more path dependency theories. It's efficient to copy others. It takes time. The lawyers can at least trust, you know, other lawyers who drafted these other constitutions. And related to that, we often got constitutional dialects, which David Law has analysed using computational methods. Fascinating, showing different dialects through constitutions. For example, the positive rights dialect is very much linked to constitutions in Spanish, where it's very, very strong, and it sort of spreads from there. And this also partly relates to legal systems, which I'll come back to. So that's recognition. Glass half full overall, perhaps tending towards full glass in some regions of the world, but not others. Middle East, for example, very low recognition. So judicial review lags significantly behind. That's because it's contested for civil and political rights. So we get Marbury and Marison, 1803, and then the next one is Norway, actually, in 1821. But it's mostly emerging in countries which have not recognised economic and social rights. When we do see that combination, we tend to see two types of developments, say in the 50s and 60s. So one is bifurcation, where, say, for example, the Supreme Court of Argentina judicially enforces labour rights, which are relatively well articulated in, say, the 1957 Argentina Constitution, whereas the social rights are very vague in the way they're drafted, and they basically say we can't enforce them. Or we get the directive principles approach, starts in Ireland, you see it in many African countries, including Nigeria. India is also famous, where you say explicitly, these civil and political rights are judicially enforceable, these economic and social rights are not. But again, we're seeing a change on this, and you can see in the graph on the left for 16 economic and social rights, where I've tracked the degree of judicial review. So now you've got 40% of countries on average actually judicially reviewing an average number of rights, half of these rights. If we add in domestic incorporation of the International Covenant on Economic and Social Rights and its judicial enforceability, it increases even more. So we have had a change over time, but not as dramatic as the recognition, the mere recognition of economic and social rights. So why? Here we could spend all day on theories of, let me put them all up there so you just get a sense of why I'm not going to go through them all, because it's a huge field, particularly in political science and sociology, as to why states judicialize or not rights. But very briefly, there's some important structural reasons. Democracy is a key influence. I mean, Ginsburg found this very early and explains why we see little judicial review in the Middle East, in Asia. So it's a key structural determinant. Another one, which is, a bit for the lawyers in a way, but it's fragmentation. So when you have a federal regime or highly fragmented states or international, national or European Union and so forth, you need judicial review for boundary making anyway. And so that means you tend to get powerful courts developing quite early. For them to then move in from that sort of boundary, decision-making on, say, federalism into judicial review is not a big step. But for unitary states, you often see judicial review developing much later because they don't take this central role in national politics that federal courts do. Then we have bottom-up demand again. Very important from the 1970s, the turn to law and courts. Duncan Kennedy's three globalizations is key here. And it happens on both the left and right. And Kagan talks nicely about both the public disillusionment with democracy, but also these creedal demands for total justice that comes out of the 68 movements. Top down, it gets very complex, lots of theories. Well, kind of a fun one from Ginsberg is basically courts are cheap. Fiscally and politically, like they're the least risky option if you're going to give anyone the job of enforcing a constitution, because they're staffed with lawyers who tend to be conservative and path dependent, so they're not going to rock the boat too much. But if you give it to like an independent institution, maybe with political scientists or sociologists, it will cost more because you've got to set up a new institution, and they might run riot with the Bill of Rights. Again, you get the political insurance model, locking in things. Trade-offs can occur. We'll give you judicial review for this, but not that. Elite pacts, this is a more critical perspective. It's basically judges doing deals with political and economic elites, shoring up their power. And some see the potential for courts to play a role in legitimating unpopular decisions and shifting blame. It's hard to know if this happens at the constitutional design process, but there's a lot of now empirical evidence showing how governments wanting to introduce unpopular measures, for example, decriminalising same-sex relations in Eastern Europe, you blame the European Court of Human Rights. It works a treat in the short term. Long-term, another question. And then you get the idea of ideational movements. Can be copying and pasting, but I think the gradual acceptance of economic and social rights evidence in courts, I think has helped in many newer processes in Kenya and all. For getting the optional protocol through was key because you can point to these examples. And so I've been in the room in both the Nepali context, Kenyan, and actually the optional protocol, where you've seen South Africa, presenting, diplomats and judges, and it has an impact. But there's also some obviously clear, path dependencies here, where, again, for example, non-Asian countries, but Asian countries are less likely to have judicial review for economic and social rights, but also common law countries. And you can see, just if you look at the non-Asian difference, common law countries, 2.9 rights on average, economic and social rights, civil law countries, 7. So it's often the opposite of what many people think, but civil law countries are a lot further ahead. And we can discuss that because that affects Australia and New Zealand. So moving into the third vector, judicial enforceability, there's basically then three sub-elements here. There's three moves that judges do. So one is, are these rights justiciable or not? And there's been functional and prudential concerns about this. Functional, can we actually have manageable legal standards that we can apply in cases because these rights are so vague, or we seem to be a policy? And prudential, we probably shouldn't do it because we don't have the institutional competence for these complex policy issues. And it's democratically illegitimate because such issues should be given to Parliament. And this economic and social rights is not the only area on this. If you look at issues like national security, foreign policy, whether the Queen can give out titles to people and so forth, all these areas reviewed as non-justiciable. But 1962 Bergen versus Carr in the US Supreme Court basically articulates a new approach, which is contextual. Which says, well, if it's judicially enforceable under a constitutional law, and there's a merit case that seems to have some merit, don't dismiss it. Go to the merits, look at facts. Is there something here? So I've called that the contextual approach here. The categorical approach lives on partly in economic and social rights. For example, Hungary and other countries, they say it's only justiciable if it's a matter of non-discrimination or if it's a matter of a minimum core. Anything else, or you fail to do anything in legislation. Otherwise, non-justiciable. But I think the Hoekboom decision in South Africa represents sort of the new approach consistent with Bergen versus Carr. If they're in the Bill of Rights, they cannot be said just to exist on paper. The courts are constitutionally bound to ensure they're protected, but they need to look at each individual case, how they are enforceable or not. And that's increasingly the approach that we see. And we've seen countries like Uganda, for example, shift recently on this. Then we've seen some courts many around the world preempt actually formal constitutionalisation by applying rights. First one off the block was really the German Constitutional Court in the 50s and 60s, drawing on sociological ideas around right to minimum existence, implying it in the Constitution, actually in tax cases first. Then the Indian Supreme Court is obviously famous. Most people here would know about all its implied rights jurisprudence. It started with actually the right to sanitation in the 80s. Then we've had the Colombian Constitutional Court develop perhaps the world's most, the greatest number of decisions ever on economic and social. We're talking about millions of decisions, basically from implying minimum core of economic and social rights into the right to life, which permits the tutela 10-day action in that state. But even countries like Switzerland have also applied. And then in terms of the content, like in terms of, if you think about constitutionalisation as the content these courts are giving to rights, it all really starts in the school finance litigation that kicks off in the late 60s. The big breakthrough decision is 73 under state constitutions, Robinson versus Cahill. The reasoning is almost exactly the same as the Hooplum decision, which comes 27 years later. But no one comparatively talks about Robinson versus Cahill. It's basically, you've got to have a plan, you've got to fund it, you've got to file it. In some ways, it's just slightly stronger than and basically, this court's finding many times the right to education is just a civil, fantastic decision in Seattle School District, where it basically goes through all the classical reasons and just dismisses them one by one by one. Then you get the so-called second wave is on equal financing for students, and that's the Robinson decision. But then you get a third wave, which is based on adequacy. So whatever the funding arrangements are, there should be an adequate level, because often more disadvantaged schools need more funding per student rather than strict equality. And then we've had non-retrogression decisions, particularly after the finance crisis, and reflexivity. Remember, there's lots of interesting, fascinating things going on. But variance in outcomes. So look at that second wave on sort of strict equality cases, only a third one, and the adequacy wave, 2/3 one. And these cases continue. So Pennsylvania, actually, its courts, going back to our first constitutional recognition, have been denying the justiciability of right to education up to pretty much now. But now there's a major decision where they're expected next month to actually find it justiciable and rule on the right to education. And generally, if you look across the world and then sort of how receptive courts are to economic and social rights, it varies dramatically. So I often talk about the US school finance cases as a future foretold. Basically, everything we find almost in the rest of the world reflects that sort of 50 years of experimentation in the US. Obviously, there's different things, but a lot of the key patterns. So there's a back of the envelope coding I've done on positive recognition of positive obligations and economic and social rights across 54 countries, from 1 out of 8 to 8 out of 8. But we can think about different archetypes. Some courts which are very formalist, don't even move on justiciability or take a very categorical approach. Some which are responsive or activists have a definition of responsive courts, and Roz also has a very similar one in her new book. But it's basically courts that are substantively engaged, concerned with the key values that have been litigated, but are also mindful of democratic legitimacy, institutional competence, and their long-term political legitimacy. Whereas other courts are more activist, they're just concerned about the underlying substantive values. But a court like Latvia is probably my favourite in actually taking that sort of responsive approach. Costa Rica and Colombia at times. Kenya moves back and forth, Nepal back and forth. And same with Portugal. And then you get these sort of mixed courts like India, very progressive jurisprudence on a number of rights, particularly those which involve the public sector. So forced eviction, health and education. So health and education. But anything involves the private sector, particularly forced eviction, labour rights, tends to be much more conservative. So that is a defining line already in the 80s and 90s, in my view. And then after the neoliberal turn in India, even in some of those more public sector areas where the public sector is the main provider, you see litigants starting to lose. So that's sort of a mixed bag. And then you have something like South Africa, which has adopted largely a deferential model or deferential light model. Some aspects of positive obligations will be enforced, but a very hands-off, light scrutiny approach to the reasonableness test, which I think the Mazabuko decision made very clear, and a lack of creativity in the types of procedures you would need to have something like responsive judging. Because courts in Germany and Colombia have dealt with much more difficult issues than we saw in the Mazabuko right to water case in South Africa. But can you increase the basic free water from 25 to 50? Or numbers? Can we actually decide something? I mean, what the approach in many of the responsive courts is, well, we don't know either, but the government should know. Come back in a year and tell us and justify what the number should be, and then we'll review it again on the basis of your reasons. So that's why I tend to be more attracted to some of the other courts in the world rather than the South African court, if we're looking for ideal models. But the South African model can be very relevant in common law context, where social rights are particularly well entrenched in policy, at least better than other countries. So UK, like Jeff King, for example, essentially argues for the South African model to be applied to the UK. I would argue the South African model is not good enough for South Africa. So that's at least my approach. So there's Latvian court, one of my favourite courts. Courts often like to have red, and we can talk about that in discussion as to why courts like red. Theories on judicial receptivity, I've run out of time pretty much. I'm not going to go into them, but they range from sort of more positivist theories, well, that was in the Constitution, that was applied it, to strategic. If, for example, the court has both the parliament and the public with them, they've got a lot of sociological legitimacy space. If they've got one or the other against them, they might be triangulating, as Tina Through argues. For example, the South African court does at times. Waranga is also the Indian court from this perspective. You have the attitudinal model. It's driven by judges' views, which may explain, for example, why the Irish courts have been so sceptical to economic and social rights if you just look at their political persuasions. Whereas in other courts where we've seen great bounds in economic and social rights, sometimes you just have a single judge who's been rather committed to. Legal culture seems to be key, and that's also probably one of the best explanations as to why the South African Constitutional Court's been so cautious, along with a sort of strategic model. But legal cultures also can change. We saw that overnight in Kenya after the new Bill of Rights. I've done training there for judges, and there was a remarkable shift because they sort of felt pushed by society, and you get these sudden paradigm shifts. We've seen the same in Nepal as well. And then structuralism, who's bringing the cases, what type of lawyers can they afford if you've got those sorts of resources, and then particularly well-framed claims. A lot of the great failures in economic and social rights cases have come from also poorly framed arguments, often too absolutist, too quick, and these sorts of things. Okay. And then just to finish on the quasi-constitutional vector, I think this is a really interesting space. And for a while, constitutional lawyers were a bit puzzled by the British experiment with the Human Rights Act. It's in legislation, we had these declarations of non-compatibility. We had experience in Canada with that, but that's at the constitutional level. But we've seen also in Norway, we had the same model on international treaties, although not the constitutional rights, which were already subject to judicial review. So I think human rights acts are one interesting area. Another, which we don't talk about so much, is more sectoral approaches. So, for example, the Homelessness Act in Scotland includes a justiciable right to housing for all homeless people if in the 10 years since the inception of the Act, they did not have access to housing. So you build basically constitutional, economic and social rights principles into sectoral legislation. There is some examples of that in sort of disability housing in say New South Wales, but it's I think a really interesting approach, and going back to particularly what Paul was talking about yesterday about thinking sectorally and introducing some sort of quasi-constitutional principles there. But institutional, we have sort of national human rights institutions. But many of those national human rights institutions don't work on economic and social rights. They're often staffed mostly with lawyers in many countries, and most of the work tends to be on civil and political rights. We have parliamentary committees, which I talked about earlier, but also jurisprudence, which is non-constitutional, like common law, customary law. I mean, the British courts have basically implied a basic right to subsistence in, British common law going back 600 years. And there's a question of whether can you get quasi-constitutionalism within the executive? Basic principles that become embedded in bureaucratic behaviour. So we can't do that. We have a constitutional custom of not doing that. So whether the glass is empty, half full or full, probably depends on where you are in the world, what your expectations are around the constitutionalisation of economic and social rights, but perhaps in a sort of a 200-year perspective where we're somewhere.
Fantastic.